Thank you very much, Patricia, for your introduction, and thank you too for organising so efficiently this this video link-up between three continents, 3 or 4 continents. I'm not sure if Mexico and the United States are on the same continent or on 2 continents. And thank you also for Northeastern for making the link-up possible here from Boston. Patricia Morales has asked me to speak for 15 or 20 minutes on the future of international justice. It's an exciting topic, and particularly because not too many decades ago there was no such thing as international justice. International lawyers knew what international law was, but they would not have been known, and they would have been puzzled by the expression international criminal law or international criminal justice. It was really in its modern guise the result of a flame that was ignited at Nuremberg in 1945 when the Nazi war criminals leaders were put on trial by the 4 victorious powers, the United States, the United Kingdom, France and the Soviet Union. And the success of Nuremberg, and it was to an extent very successful in establishing that there could be such a thing as a multinational criminal trial. It had never been tried before. This was the first time, and it worked pretty well, and it did bring some form of justice to the German people in particular, but to the Allied countries, to the victim countries as well. And it was sufficiently successful for international lawyers to believe and hope that there would then in the near future be a permanent international criminal court created by international treaty. And if one wants evidence of that, you have to look no further than Article 6 of the Genocide Convention of 1948. That convention provides that the crime of genocide, this horrible new crime that came out of World War II, that the crime of genocide could be tried in national courts, in domestic courts, in countries where the crime was committed, or in an international court having jurisdiction. And it was assumed that there would, as I say, soon be an international court having jurisdiction. Unfortunately for the world, the Cold War intervened, and the Soviet Union and China too were completely resistant to an international criminal court being established, and the whole endeavor was really put on ice, and nothing happened for almost half a century. And then in 1993, in light of the terrible crimes that were being reported from the former Yugoslavia, the Security Council decided to set up the first ever truly international criminal court, the International Criminal Tribunal for the former Yugoslavia. And that wasn't a victor's court, it was a court established by the Security Council, and the judges didn't come from the countries where the crimes were committed. They came from many countries on 5 continents. And that was an experiment in a way, and it was a surprising one because it was done by the Security Council under Chapter 7 of the United Nations Charter, which made it binding on all member states of the United Nations, including obviously the states of the former Yugoslavia, Serbia, Croatia, and Bosnia-Herzegovina. There then followed the Rwanda genocide in April, May, and going into July of 1994, and at the end of 1994, the Security Council, at the request initially of Rwanda, set up a second tribunal. Now, these tribunals were set up only because of really a congruence of a number of factors. The first was the Cold War had come to an end in 1989, so politically there was a window of opportunity for the international community to take the step and set up an international criminal tribunal. Secondly, the terrible crimes in the former Yugoslavia were happening in Europe. And after World War II, the Europeans said, well, this is never going to happen again anywhere, but particularly not in our part of the world. And here it was happening literally in their back garden, roughly an hour's flight from Rome or Venice into Sarajevo. And the Europeans, joined by North Americans, the Canadians, and the United States, decided that something had to be done about it. And they decided really the least that could be done about it was to set up an international criminal court as a form of peacemaking. And I'd emphasize that because in order for the Security Council to do what it did, to set up an international criminal tribunal, legally speaking, it only had the power to do it under its peacekeeping powers under Chapter 7 of the Charter. It had to make a link between peace and justice in order to make the establishment of the tribunal legal. And it did exactly that. It said that having an international criminal tribunal would assist peacemaking in the former Yugoslavia. And we can discuss the ways in which I certainly believe it has to, at least to a limited extent, had a good influence on bringing about peace in the former Yugoslavia. Then there was what is often referred to as the CNN factor. There were the horrible photographs of emaciated men with their ribs popping out of their chests in prisoner of war camps in Bosnia. And that reminded people, again, particularly in Europe, of the photographs that came out of the Nazi concentration camps in the Second World War. So it was these events that led mainly the United States to push for an international war crimes tribunal for the former Yugoslavia. And the greatest single proponent of that was then Ambassador Madeleine Albright, who was the permanent representative of the United States at the United Nations. And she, more than any other single person, was responsible for setting up the tribunals, and more importantly, and from my own experience as the first chief prosecutor there, I can assure you that those tribunals would not have got working but for the resources, the political clout coming from Washington, D.C. So that was the beginning of a new era of international criminal justice. And it's really quite amazing how quickly it's grown since then. The Rwanda Tribunal, as I've said, was added because of the horrors of the middle of 1994 and the request coming from an African country. The Security Council could hardly refuse an African request, having acceded to one for a European tribunal. So the Rwanda Tribunal was set up, and the two worked side by side, and there was a common prosecutor. I became the chief prosecutor literally overnight for the Rwanda Tribunal as well, which was a difficulty because there were thousands of miles between the office of the prosecutor in Kigali in Rwanda and in The Hague for the former Yugoslavia. But the tribunals worked hard. That was difficult in the beginning. They were completely new animals in the United Nations stable, and that made it difficult to staff them, to get financial resources from the United Nations. But those difficulties were overcome, and the judges came. Initially there were 11 judges from 11 different countries. In Rwanda there were initially 6 judges from 6 different countries, and those numbers have increased in the interim because of the huge increase in the number of cases that have been heard by both tribunals. And the successes of the tribunals have been a number. First and foremost, in my view, is that they have advanced humanitarian law. The law of war, as it used to be called, now humanitarian law, the Geneva Conventions, customary law of war, crimes against humanity, and genocide, have been advanced because they've been used.